Standing until the conclusion of the reading of the proclamation. Ladies and gentlemen, the proclamation. All persons having any business before this honorable court, please draw nigh, give your attendance, and you shall be heard. God save the Queen.
Justice Baston, I have the honour to announce that I've been appointed Chief Justice of this court. I present to you my commission.
Thank you. Principal Registrar, will you read the commission, please? Please sit down.
By Her Excellency, the Honourable Margaret Beasley, Companion of the Order of Australia, Queen's Counsel, Governor of the State of New South Wales in the Commonwealth of Australia. To the Honourable Andrew Scott Bell, President of the Court of Appeal. Greeting. Whereas by the Supreme Court Act 1970, it is enacted that the Governor may, by commission under the public seal of the state, appoint any qualified person to be Chief Justice of the Supreme Court of New South Wales. Now I, the Honourable Margaret Beasley, AC, QC, the Governor aforesaid, in pursuance of the power and authority vested in me, in that behalf, do, with the advice of the Executive Council of New South Wales, hereby appoint you, the said Andrew Scott Bell, being a person qualified to be so appointed, to be Chief Justice of the said court on and from the 6th day of March 2022, provided always that you shall, except in case of leave of absence duly granted to you, actually execute the office to which you are by this commission appointed. Given under my hand and the public seal of the said state this 16th day of February 2022. Signed, Her Excellency Margaret Beasley, Governor, and by Her Excellency's command, Mark Speakman, Attorney General.
Thank you. Principal Registrar, do you have the form containing the affirmations, the affirmation of allegiance, and the judicial affirmation? Thank you. Chief Justice, I now ask you to rise and take the affirmations of office, first the affirmation of allegiance and then the judicial affirmation.
I, Andrew Scott Bell, do solemnly, sincerely and truly declare and affirm that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors, according to law. I, Andrew Scott Bell, do solemnly, sincerely and truly declare and affirm that I will well and truly serve our Sovereign Lady Queen Elizabeth II in the office of the Chief Justice of the Supreme Court of New South Wales, and I will do right to all manner of people after the laws and usages of this state without fear or favour, affection or ill will.
Chief Justice, if you will resume your seat and subscribe the oaths, and I will attest them. Principal Registrar, if you'll place the oaths with the court's papers. Thank you.
Ms. Reid, I invite you to offer an acknowledgement of country.
Yuradu, Marang, Yingyaki, Yuindi, Tila, Nadu, Winangnange, Yinjimar, Marange, May. Durinya, Gadigubu, Nurembangabu. Good morning, everyone. I acknowledge the first people to be born to this country, and I pay my respects to the Gadigal as the first peoples of this country. I acknowledge this country and the sovereignty to the lands and waters has never been ceded. Your Honours, this is not my traditional country, nor is it yours. I stand before you today as a proud Wiradjuri and Walwan woman from my community in Gilgandra, Western New South Wales. I acknowledge the stories, the wisdom, and the courage of the Gadigal. Waters and skies, a people who have felt the full force of colonial laws that invaded this place. Chief Justice Bell, it is at Your Honour's personal request that I deliver this acknowledgement to country. I've come today with my grandfather's boomerang, carved from my country, as a symbol of my ancestors. It was my grandfather's final instruction to me that I continue to fight to empower my people. An instruction that has led me to a career in the law. I also acknowledge that this country is on the cultural authority of the Metro Local Aboriginal Lands Council. I urge this court and those present to take these words and turn them into action. It was in this very court that the outgoing Chief Justice Bathurst sat before the bench. This bar table was brimming with First Nations advocates. His Honour looked at the portraits around the room and hoped that one day our legal system would reflect the community it serves. I acknowledge this country. I acknowledge that it always was and always will be Gadigal land. I acknowledge the ancestors' calls for peace on their country. I acknowledge their continuing connection to their traditional laws and customs. And I acknowledge that their sovereignty was never ceded and coexists with the sovereignty of the Crown. As the Uluru Statement from the Heart so powerfully puts, how could it be otherwise that a people's possessed a land for 60 millennia and this sacred link disappears from world history in merely the last 200 years? With substantive constitutional change and structural reform, we believe this ancient sovereignty can shine through a fuller expression of Australia's nationhood. May it please the court.
Thank you, Ms. Reid. Justice Baston.
As Ms. Reid has just powerfully explained, we are gathered on the traditional lands of the Gadigal people of the Eora Nation, lands of which they were dispossessed many generations ago and without due process of law. We offer our respects to their elders and descendants, past and present. Chief Justice, on behalf of the Supreme Court, the judges, judicial staff, court officers and staff, may I warmly welcome you as the Court's 18th Chief Justice. It is an honour to do so in the presence of your immediate predecessor as President of the Court of Appeal, Her Excellency the Governor, former Chief Justices of the High Court and of this Court, Chief Justice of the Federal Court, other senior members and former members of the judiciary, the legal profession, your family, and distinguished guests. We are proud of you and of your appointment. Others will speak of your many qualities and achievements, including, I expect, your mischievous self-assurance under pressure. May I give one example? At the bar, you were counsel of choice in large commercial matters involving private international law, but not always. Some years ago, one of your predecessors as president, now Chief Justice in another place, was conducting a list in the Federal Court in Perth. He called a maritime dispute involving a collision with a ship flying a foreign flag. Other counsel rose to announce their appearances. Seeing you at the bar table, the judge chided you. "Are you not in this matter, Dr. Bell?" Your response, "Not yet, Your Honour." Chief Justice, you are eminently qualified for your new role. In the last 3 years, you have deftly presided over the Court of Appeal, sat on trials in both divisions, and assisted your predecessor in managing the court through seriously challenging times. You have run the Court of Appeal with expectations based on your own high standards, transparently and with self-deprecating charm. With you as Chief Justice and Justice Julie Ward as the new President of the Court of Appeal, the community can be assured of continued excellent leadership in the administration of justice in this state. Your appointment is welcome for another reason. At a time of high international tension, when the worst achievements of the Anthropocene epoch are making their mark in our country, the Pacific region, and the world, where other places with similar legal values see social fault lines harden and the politicization of judicial appointments, your appointment maintains a tradition which allows us all to have confidence in the independence and integrity of our courts. Thank you.
Thank you, Justice Besson. Mr. Attorney.
May it please the Court. I acknowledge the traditional custodians of the land on which we gather, the Gadigal of the Eora Nation, and I pay my respects to their elders, past, present, and emerging. Your Honour, Chief Justice Bell, on behalf of our state and the bar, it's my great pleasure to congratulate you on your appointment as our 18th Chief Justice. I acknowledge members of your family who are here with us today, your wife Joanna, your children Lucy and Tom, your brother David and his wife Michelle, and your mother, Dr. Pamela Bell. The memories and anecdotes shared by your family, friends and colleagues paint a portrait of someone of extraordinary intellect, of extraordinary work ethic, of great empathy, with a special penchant for bringing people together, and with a great sense of humour that you turn on yourself as much as anyone else. Your early life was spent on the lower North Shore of Sydney. You attended 4 schools, Balmoral Infants, Mossman Primary, Neutral Bay and Sydney Grammar, where you were captain of the cricket team. Later on, there was debating that took your honour interstate and overseas as part of the intervarsity competitions and world championships where you had great success. I think I've just lost the mic. No, it's back. But there was also early talent on display for advocacy at Sydney Grammar. Sydney Grammar had a fundraising chocolate drive in the lead up to Easter, where the boys were to sell overpriced chocolate bunnies and eggs with the surplus going to a good cause. A student with the gift of the gab was chosen to address the assembly and rally for the cause. You were that chosen one. You stood in front of the assembled boys and told them, chocolate does not cause acne, chocolate is healthy, chocolate is delicious, and everyone should therefore purchase lots of bunnies and eggs. It's been said you did this with such sincerity that you must have believed it to be true. Your intellectual prowess was evident early on. At Sydney University, you completed a Bachelor of Arts with the University Medal and First Class Honours, followed by a Bachelor of Laws with First Class Honours and the University Medal, as well as the Convocation Medal. Having excelled at Sydney, Your Honour went on to Oxford as Rhodes Scholar for New South Wales, topping the Bachelor of Civil Law, and then finishing your doctorate in the lightning speed time of 1 year. On your return, you spent 1990-1991 as the Associate to the then Chief Justice of Australia, Sir Anthony Mason. You joined the bar in 1995, reading on 11 Wentworth with Phil Greenwood. Your arrival at the bar also showed your foresight in choice of topic for doctoral thesis. Your Honour's arrival at the bar coincided with securing a brief in a major Supreme Court case in which Australian courts were, for the first time, being asked to consider cross-border disputes and forum shopping. In 2003, your thesis formed the basis for your book, Forum Shopping and Venue in Transnational Litigation, published by Oxford University Press. It was the first in-depth study on the topic. Despite this extraordinary start, There was one major disappointment in your early life at the bar. You were known to love travel, even for work. You were briefed to travel to London, flying first class, for a lengthy arbitration case. No expense was to be spared. London hotels booked, and perhaps even tickets to Lord's. All was set. You were wearing a special pale pink suit for the occasion. A limousine waited on Phillip Street, and as you were loading your bags into the back, a call came through. The case had settled. You commiserated with a long but slightly mournful lunch the next day. Your Honour was known for your prodigious work ethic. You often worked late into the night. It was dangerous for your juniors to take a call at late hours. An unwise junior would pick up the phone to be met with a stimulating conversation about the next day's cross-examination and other such events. While they were feeling sleepy, you were wide awake and firing on all cylinders. You'd then be up early and ready to go the next morning with the day's witnesses. You were one of the bar's most enthusiastic cross-examiners. You normally didn't deploy a rapid-fire technique. Rather, your technique was to and ah your way through questions, letting the witness leap in and volunteer information when seized, as they often were, with the overwhelming desire to help the jolly but sadly uninformed chap who was talking so freely with them. Once, when cross-examining a witness in another country by video link, it seemed to you that the witness was being even more solicitous than usual, agreeing with everything you put. Suddenly the penny dropped. You whispered to your opponent, "He thinks I'm you." The opponent groaned, and when the opponent got up and tried to patch the damage in re-examination, the witness, of course, rejected everything put. You rejected any axiom of open low, close high. Your opening submissions were always punchy. You normally instructed your junior that you'd had enough to cross-examine on for weeks, and there was no point keeping anything back. Your view was that the critical thing was to get into the judge's mind early, and that is what would win the case. You were famous for never refusing a brief on the ground of lack of time, no matter how busy. Somehow you fitted them all in, burying yourself in detail when needed, and immune from the outbursts that such a workload would induce in others. Your Honour appeared in some high-profile cases. These included acting for Qantas against Rolls-Royce, the Reinhardt children in trust litigation against Gina Reinhardt, and Channel 7 in relation to cases arising from the AFP raid. You appeared in 30 High Court appeals and more than 80 appeals from the New South Wales and Western Australia Courts of Appeal, as well as appearances in the full court of the Federal Court. By the time of your appointment to the bench, you'd accumulated 24 years at the bar. You were sworn in as Justice of this Court and President of the Court of Appeal in February 2019. Shortly after your appointment, you went to the National Judicial Orientation Program, in which all new judges are advised to participate. You reported back that you got a lot out of it, in many ways. But one of the things that pleased you the most was to learn that apple juice has a higher sugar content than champagne. You've presided over a wide range of cases and handed down a number of important decisions dealing with matters of public interest, principles of civil procedure, and matters of criminal law. On public interest, during the pandemic, you've dealt with important matters such as a challenge to the validity of public health orders and restrictions on public assembly in relation to Black Lives Matter's protests. You've added some clarity to the fettering doctrine, the doctrine that a government or public authority may not fetter the future exercise of discretionary powers reposed in the executive or public authority. In relation to compensation sought under the Victim Rights and Support Act for acts of violence occasioned overseas but by an Australian citizen, you provided clarity as to the extent and scope of that legislation. You've clarified the powers granted to commissioners under the Royal Commissions Act to compel the production of documents, including the production of legally privileged documents. Your decisions have addressed important matters of civil procedure, including whether an abusive process exists, where proceedings with some overlap are brought by different plaintiffs against the same defendant, providing clarification on the requirement that a subpoena be issued for a legitimate forensic purpose, and upholding the necessity for a fair trial by permanently staying proceedings against the defendant with severe dementia in civil proceedings for damages arising from historical sexual assaults. On the bench, you've dealt with notable cases in crime, including those concerning the Bugme principles, and in the infamous case of Roger Rogerson and Glenn McNamara, the Evidence Act and tendency evidence. In transnational litigation, your doctoral thesis, specialty of anti-suit injunctions, has come to the fore. In commercial and corporations law, there have been a number of important decisions, including looking at unconscionability in light of material change of circumstances and misleading or deceptive conduct by silence. You've also sat at first instance in the common law and equity divisions, including a 7-day hearing of a civil contempt motion with a further day-long hearing on penalty. Your ever-growing library of extracurrial speeches has involved a wide range of topics, from recurring appeal issues to other members of the judiciary, to the laws surrounding modern-day gambling, to High Court justices who never sat, all echoing your breadth of experience. Your contribution on the bench and in extracurrial speech mirror your ongoing contributions to the legal profession throughout your career. At 11 Wentworth, Your Honour was twice chairman of the floor. Here you were known to foster a collegiate, inclusive workplace, so much so that you had the title Chairman of Fun. You signed off most communications with this title. It was substance as well as form. You immediately doubled the number of floor lunches and reinstated party pies as standard issue at any floor event. The Chairman of Fun mainly walked around in a white linen suit. At floor lunches, you made sure there was diversity in the judicial guests invited. And even when you weren't chairman, you were seen as leader on the floor. You were a leader intellectually and socially. Your Honour is known to be a rather social character, often being the last to leave a social event. Your contribution to the legal profession has been significant. You've been Senior Vice President and Treasurer and a member of the Bar Council, on a Professional Conduct Committee, the Finance Committee, the Education Committee, the Editorial Committee, and editor of Bar News. You were Adjunct Professor of Law at Sydney University and a member of the St Paul's College Council. You've also published widely, including co-authoring Nye's Conflict of Laws in Australia. Throughout your career, you've been a beacon for young people. Your door was always open and you were always available as a mentor at 11 Wentworth and in St Paul's College. And I'm told that mentoring tips days at the Supreme Court is one of your great joys in that role. If your prodigious work ethic were not enough, you've somehow managed to have a life and interests outside of the hard taskmaster that the law is. Many have been in awe of how you have managed to be chairman of Sculpture by the Sea while having a full-time practice at the bar. This is a role that involved fundraising and working alongside artists and business people. It's a testament to your ability to connect with people from many walks of life and the breadth of your knowledge and interests. You have a keen interest in getting to know people, what interests them and what concerns them. Throughout your career, you prioritise spending time with your wife and children. You've spent a lot of time walking around cricket pitches on Saturdays, watching your son play. Your son completed the HSC last year, which frees up a bit more time for you to be on the golf course. Your Honour is a keen golfer, I'm told, always trying to improve. Chief Justice Bell. Thank you for your outstanding contributions to the law and for your service to the law to date and for those to come. Your intellect, experience, empathy and humanity will be invaluable assets for this court and for the justice system in New South Wales. Congratulations on your appointment and best wishes for your career as Chief Justice. May it please the court.
Thank you, Mr. Attorney. Ms. van der Plat, President of the Law Society.
May it please the court. I too acknowledge the Gadigal people of the Eora Nation, the traditional owners of the land on which this court stands, and pay my respects to their elders past, present and emerging. I acknowledge and extend my respects to any Aboriginal and Torres Strait Islander people who are with us today. Chief Justice, it is a great privilege to come before this court on behalf of the solicitors of this state to congratulate you on your appointment to the office of Chief Justice of the Supreme Court of New South Wales. When Your Honour was first appointed to the bench, you were described by solicitors as one of the most brilliant lawyers of your generation. Your collegiality, intellect, and prodigious work ethic became hallmarks of Your Honour's time on the Court of Appeal. At last week's farewell for your predecessor, Your Honour was paid one of the highest of compliments, to receive his trust and confidence. I don't think I can top that. But what I can do is reflect on your remarkable tenure as President of the Court of Appeal and consider how your leadership over the last 3 years gives us insight into the state's 18th Chief Justice. Under your leadership, the Court of Appeal has thrived as a place of collaboration and teamwork. A happy collegial place was how one Court of Appeal judge described it. Your leadership is widely credited in helping promote this. At the height of the pandemic, Your Honour championed the practice of having Court of Appeal judges participate in hearings of the Court of Criminal Appeal. This was an approach also adopted by judges in the equity and common law divisions. Your Honour knows that, in the court as on the cricket pitch, teamwork is essential for success. Your Honour has worked hard to break down the silos in the justice system and actively encouraged the transmission of ideas and insights across divisions and jurisdictions. Your Honour's collegiality is founded upon the strongest of interpersonal skills, boundless energy, and in the words of one of your colleagues at the bench, being intensely social. While serving as President of the Court, Your Honour continued to innovate by establishing the Court of Appeal barbecue. I like to think of this as something akin to the democracy sausage, although rule of law sausage doesn't quite have the same ring to it. The general consensus was that, due to COVID, it didn't meet quite as often as Your Honour would have liked, but when it did, it was a great success. Your Honour appointed a fellow judge to serve in the office of Barbecue Master. I am reliably informed this office, at least in matters of meat and the grill, sits just below Chief Justice. Your Honour is a prodigiously hard worker, but never a dour one. We should also expect the court under your leadership to continue to be defined by its speed and effectiveness. When the pandemic first hit our shores and the nation moved into lockdown, commentators spoke of the great slowdown. Your Honour, together with your colleagues on the Court of Appeal, didn't seem to get that memo. In an article for the New South Wales Bar Association, Your Honour took obvious pride in the fact that the Court of Appeal continued to sit uninterrupted throughout the COVID-19 crisis. In 2020, the Court of Appeal delivered 361 judgments, nearly 80% of which were delivered within just 3 months of hearing. If that sounds fast, consider the fact that Your Honour, together with the Chief Justice and Justice Gleeson, heard an appeal on the 9th of March 2020 and delivered judgment just days later on the 12th of March. The matter concerned the powers of New South Wales Inquiry into Crown Resorts, particularly around legally privileged documents, and the ruling, which later clarified the inquiry's powers, enabled its efficient continuation and later much public good. Your Honour has been effusive in your praise for how the judiciary and both branches of the profession have embraced technology and adapted to change during the pandemic. But it is not only the court that has adapted. Your Honour has helped society at large, particularly the market, respond. In a matter concerning business interruption, insurance policies and the pandemic, Your Honour convened a 5-judge bench to hear a case, removed from the trial court directly into the Court of Appeal to enable commercial certainty. In this case, we see 2 of the great hallmarks of your leadership: swift, sound reasoning, and a collegial approach to the law. Finally, we should also expect your leadership to be both bold and outward-looking. Your Honour is a great scholar, but never one for ivory towers. Your Honour relished attending the University of Newcastle's admission ceremony at City Hall last year. and you were proud that the Court of Appeal has had sittings in both Orange and Newcastle. As President, Your Honour travelled to Singapore in 2019, meeting with Chief Justice Menon and delivering a well-received paper on an Australian International Commercial Court. Not a bad idea, or what a bad idea. When your predecessors spoke of the importance of the Supreme Court maintaining an outward-looking focus, he knew the court was in safe hands. I would like to conclude today by quoting one of our members, who I think is representative of our profession. Justice Bell's appointment as Chief Justice has been welcomed and embraced with enormous enthusiasm by solicitors in New South Wales. We know his good work, his good humour, and his ability to provide effective leadership as part of a team. We have seen that in his work at the bar and as President of the Court of Appeal. On behalf of the solicitors of New South Wales, congratulations, Your Honour. Your appointment is very well deserved. And on the eve of the court's bicentenary, the solicitors of New South Wales have every confidence that you will make an exceptional Chief Justice and lead us well into the next 200 years. As the court pleases.
Thank you, Mr. van der Plat. Your Excellency and Mr. Wilson, Chief Justice Alsop, Justice Gleeson, Attorney Mr. van der Plat, Ms. Reid, distinguished guests, members of the profession, ladies and gentlemen. The Gadigal people of the Eora Nation have cared for and been custodians of the land on which we meet for thousands of years. I pay my respects to their elders, past, present and emerging, and I extend those respects to all Aboriginal and Torres Strait Islander people, and particularly this morning thank Ms. Teela Reid for delivering a powerful acknowledgement to country. Ms. Reid was recently a tipstaff in this court, is a practicing lawyer and has recently taken up an important position as the first Indigenous practitioner in residence at the Sydney University Law School. I acknowledge her very important contribution to this occasion and also express my support for the Uluru Statement from the Heart to which she referred. It is an eloquent, accurate and powerful statement which looks forward to a fuller expression of Australia's nationhood with great dignity. In the spirit of the Uluru Statement, I acknowledge the regrettable reality that this nation's laws and legal systems have so often in the past delivered the opposite of justice to our Indigenous people. One lawyer who, for many years prior to his appointment to the bench, was at the forefront of seeking to address and redress injustices to Aboriginal people was my colleague, the Honourable Justice John Baston, the Senior Judge of Appeal and one of the finest jurists in this court's history. I was delighted to be able to present my commission to him today. I must, at the same time, confess a slight degree of relief that His Honour apparently found no reviewable error in the commission. Although perhaps he had some doubts about the justiciability of the issue. I thank Justice Baston most sincerely for his kind words of welcome on behalf of the court and also for his almost 2 decades of service on the Court of Appeal. I also thank you, Mr. Attorney, for your generous remarks and for the confidence you and your political colleagues in the government have placed in me with this appointment. The Attorney's participation in and contributions to sittings of institutional significance such as this are greatly appreciated by the court and I'm sure by the entire profession throughout which he is widely respected. I thank you also, Ms. van der Plat, for your very generous remarks and congratulate you on your recent ascension to the role as President of the Law Society of New South Wales. Both the Law Society and the Bar Association play critical roles in the regulation and continuing education of the legal profession in this state. More than that, though, through their diverse activities, they seek to ensure that legal practitioners feel part of the profession in the proper and full sense of that word. It is a far more diverse profession than when I commenced practice, and so much the better for that. The practice of the law is quite deliberately to be contrasted with the conduct of a business. That does not mean that it cannot be vital and dynamic. It should be. but it does mean that the day-to-day work of lawyers is underwritten by the strong ethical requirements upon which their admission is conditioned, reflecting their status as officers of the court. I acknowledge the presence today of former Chief Justices Spiegelman, Bathurst, and I think former Chief Justice Gleeson may be suffering from Sydney traffic. He's here. Excellent. Excellent. The flexibility of the Supreme Court of New South Wales. I'm delighted that he is here as well. Together, these three significant figures form part of a long history of Chief Justices of New South Wales who have dedicated themselves to the service of the administration of justice in and of the state. I dedicate myself to the same honourable goal. My predecessors set a very high standard for the role of Chief Justice. That was entirely appropriate, and I am deeply honoured to have been entrusted with the large responsibility of maintaining that standard. I do hope that in the discharge of the office, I will exceed the assessment of a high school teacher of mine who wrote on one of my school reports, quote, "Results quite good, but the obvious tends to elude him." Before moving on, I must acknowledge another Chief Justice and a man for whom I have the deepest admiration and affection. That is, of course, Sir Anthony Mason, whose 97th birthday I look forward to celebrating next month. His presence here today means so much to me, as indeed does the presence of all of you here in court who do me and the court enormous honour by your attendance. Everyone in this courtroom can count him or herself fortunate, and I am sure you would join with me in expressing profound sympathy and sorrow for the thousands of our fellow citizens who have sustained devastating loss on account of the terrible floods in northern New South Wales and Queensland. Our thoughts and hearts today are with them as they are with the people of the Ukraine who are confronting a different but still terrible tragedy. Today, I assume the stewardship of a highly respected institution, which, thanks to Tom Bathurst's leadership, of which I spoke a week ago, is in very good shape indeed. It is constituted by a fine cohort of dedicated judges, assisted by an equally dedicated band of associates, tipstaves, registrars, librarians, court and registry staff and reporters. I thank them for the often unheralded work they all do in supporting the court and the administration of justice in New South Wales. I look forward to continuing to work with them all. My values as a lawyer and a judge are, I hope, well known. I place great store on legal excellence and intellectual honesty, hard work, decency and integrity, civility in the practice of the profession and in the conduct of hearings, and collegiality within the court and in the wider profession. It has always been both my view and my experience that institutions and organisations work best and thrive if their environment is mutually supportive, cooperative and congenial. This is scarcely rocket science, but it is sometimes lost sight of as lawyers become absorbed in their cases, their trials and their judgments. Judges of this and other courts and the magistracy work under enormous pressure, and it is important that they derive satisfaction from and are not overborne by their work. It is also important that their industry and contributions are valued and acknowledged. To be appointed a judge is a high calling, and the judges and magistrates of this state should be proud of the work they do. It is difficult work, and as my friend the Honourable Paddy Bergen recently observed, judging is not for the faint-hearted, it is for the strong-hearted. It takes strength to make difficult decisions. It takes strength to deal with the subject matter of many cases, particularly in the criminal sphere, and it takes strength to deal with the sheer volume of work before the courts. But this strength must be tempered by a lived understanding of human nature, compassion, respect and empathy, an informed appreciation of systemic social problems, and an innate sense of fairness, both in terms of substantive outcome and the procedure by reference to which that substantive outcome is achieved. The significance of the work of the Supreme Court of New South Wales extends far beyond the resolution of the several thousand cases it deals with each year. As important as the quelling of controversy in any given case is to the parties involved, every decision given by this court reinforces and publicly affirms the fact that we have in this state a system of justice that is administered fairly and impartially in open court by judges who are independent of the executive government and who are of the highest integrity and calibre. It is a system of justice in which the citizens of New South Wales may have confidence, and without which the rule of law on which our democracy rests would be an empty letter. In just over 2 years' time, the court will mark its bicentenary. That milestone will be celebrated as it should be, not simply for its own sake, but because of what it says about our society and its enduring values, the preservation and enhancement of which are central to the court's broader role of which I have spoken. This message is important. I do not want to see a society where, for example, despite the clear and unanimous rulings of a series of superior courts, a significant percentage of the population does not accept the outcome and integrity of a democratic electoral process. Where is respect for the judiciary and the recognition or understanding of the importance of its role and independence in this fact? Nor do I want to see a society in which a political leader says, as a former United States president is reported to have said, that he expected his judicial nominees to, quote, do the right thing, unquote, by his or her appointer. That, frankly, medieval notion is anathema to and corrosive of a fundamental tenet of modern democracy. These examples supply powerful reasons why public education as to the role of the courts, the importance of judicial independence and respect for the rule of law in our society is essential and matter. They are not matters of mere theory. The celebration of the court's bicentenary will be most important in this regard. For the immediate future, my strong hope is that 2022 is the year which sees the reversal of the unintended but insidious depersonalisation of the legal profession brought about as a result of COVID. That is not to criticise the legitimate and responsible public health measures that were imposed, the legality of some of which were upheld in this court, but it is to observe that whilst the remote practice of law may be possible, it is far from desirable. The administration of justice is best served in open court for reasons which are profoundly important. More than that, though, the absence of practitioners from chambers and solicitors' offices will sap them of vitality and will stunt the personal growth and professional development of young lawyers in particular. An essential part of being a good lawyer is understanding people and human nature, how others react to different situations, perform under pressure and interact with each other. So much of this is lost in a professional practice or hearings reduced to scheduled Zoom or Teams meetings. What hope, moreover, is there for achieving work-life balance in the profession when work takes over the living room or the bedroom at home and further blurs an important distinction. It is incumbent on senior members of the profession to take the lead in the return to professional life as we knew it more than 2 years ago. Just as there is nothing quite so demoralising or dispiriting as walking down a strip of shops to find half of them empty, chambers and solicitors' offices which are half full will rapidly lose their soul and personality. That would be a very bad thing. It must not happen. I do not mean by this to suggest that there are not real opportunities and benefits presented by the technology with which we have all become familiar and the concomitant advantages of workplace flexibility and significant cost savings. Both of those considerations are very important. Moreover, as we have seen, the use of technology to broadcast the workings of the court to large audiences, as happened, for example, in relation to the Queensland floods litigation and the challenge to the COVID-19 regulations, significantly enhances the public's access to and understanding of the workings of the courts. Contrary to the opinion of my colleague, the Chief Judge at Common Law, I ascribe the popularity of the live streaming of these cases not to his charisma, magnetic though it may be for a Tasmanian, but I ascribe it to the genuine public interest in the subject matter of the cases and in the legal process let me go off script for a moment. The challenge to the COVID regulations held last year represented justice in New South Wales at its finest. Some people, a minority, a small minority of people, took violent objection to the regulations. They brought proceedings, as they were entitled to do. Those proceedings were listed and heard within a week. Justice Beach-Jones delivered his reasons within a matter of days. It was a 4-day hearing. The case went on appeal to the Court of Appeal, which heard it the following week, and we gave our reasons 3 days later. That is justice in New South Wales. There was respect for the citizens who brought that challenge. They were entitled to that view. Their case was presented with arguments of varying degrees of strength, but some of them were strong arguments, and they were permitted to present that case without hectoring, without majoritarian judgment, and it was a matter which I thought represented the law operating in our society as it should. Now, I mentioned that Justice Beach-Jones took a view about the popularity of the hearing, and there is perhaps something to his point that the numbers dropped right off when both cases went to the Court of Appeal. But on the subject of the Court of Appeal, of which things have been said this morning, and which I've had the privilege of leading for 3 years, I do want to say just this. It is, in my view, not only as strong an appellate court as any in the common law world, but it is also one whose capacity for hard work is probably without equal. I would not expect that to change under the incoming President, Justice Ward, whose work ethic and dedication to the discharge of her judicial duty is second to none. Her role in the court has been and will continue to be central to its success and high reputation. I very much look forward to continuing to work with her, with the telegenic Justice Beach-Jones, another outstanding lawyer and excellent administrator, and the incoming Chief Judge in Equity. Pursuant to the Judicial Officers Act 1986, the Chief Justice is also the President of the Judicial Commission of New South Wales. I'm delighted that members of the Commission are present today and take the opportunity to pay public tribute to the work of the very recently retired Chief Executive of the Commission, Mr. Ernie Schmatt, AM, PSM, who has served the administration of justice in this state in that role for the last 33 years. On a personal note, 3 years ago I acknowledged my family for their great love and support. 3 years on, Lucy is gainfully employed and a very witty and amusing young woman. Tom has scored more runs, left school and is now at the ANU, although I'm so pleased he is here today. And Joe's very large job at ASIC has become even larger, a more dedicated and hard-working senior public servant and a more supportive and loving partner I could not imagine. To all of them, and my mother Pamela, who I'm also thrilled is here today, I owe an enormous debt. I thank them for their love and support, which is wholly reciprocated. And so, to work. The court will now adjourn.
All stand. This honourable court is now adjourned. God save the Queen. Would you all remain standing until the Chief Justice and judges have departed the court, as well as the Governor of New South Wales, Her Excellency Governor Margaret Beasley and Dennis Wilson.